On this episode of Law Weekly, we look closely at the relationship between the executive and the judiciary in the last 4 years. We talk about the need for some reforms with a senior advocate of Nigeria, Anthony Idigbe. We also have some lawyers weighing in on the move by some lawmakers to pass into law life pensions for members of the legislature, plus our weekly recap of the top trending stories from the courtrooms. Hello and welcome to the program. I am Shola Shuyeli. As we count down to the May 29 swearing-in for elected officials across the country, it is proper to attempt to look at what has been in the last 4 years and what could be better. Our focus today is on the executive-judiciary relationship under the present administration. My guest, Senior Advocate of Nigeria, Anthony Idigbe, has over 30 years' experience in diverse areas of the law. In 2016, he was appointed chairman of the Nigerian Bar Association Legal Profession Regulation Review Committee. In this interview, he shares his views on some of the much-needed reforms in the legal sector. But first, I asked him to assess the relationship between the executive and the judiciary under the present administration.
Well, very much cat and mouse relationship, if you ask me. There's been a lot of tension between the executive and the judiciary during the tenure of our current president. However, I think that tension could have been better managed by both parties. In very many ways, there are some endemic problems with the constitutional arrangement that has sort of magnified the tension. You know, usually constitution is based on checks and balances. There is hardly 100% separation of powers. And it's very important to appreciate that there's no 100% separation of powers. However, if you look at our constitutional arrangement, particularly around the establishment of the judiciary, it says that the president will act on the recommendations of this body, in which there's no input from any other arm of government. And so the president had very limited discretion. Really, the appointments were practically made by the council. And then the chairman of the council is the CJN, who had a lot of powers, who appointed and nominated majority of the members. So it was basically a whitewash, as it were, in terms of the composition and key sectors of the even the of the legal profession did not have any input in how people are appointed, including those that have been represented. Let's take, for example, if senior advocates were, say, appointed, the CJN appoints them. So not the body of senior advocates. There's no election within the senior advocates as to who will represent them there. So when they go there, they don't actually represent the interest they're supposed to represent. They represent the interest of the appointer. And even with respect to the lawyers, they are not appointed by the lawyers directly through an election, for different zones, but by the president of the Bar Association who nominates them. So they will be loyal to whoever appointed them. So these have affected effectiveness of the National Judicial Council.
With all of these issues that you've raised, what reforms do you think will work?
Well, you know, I chaired the NBA committee for the reform of the legal profession, and we submitted a report. We considered most of these issues that I've been talking about. We did a good analysis. They are historical. We did comparative analysis of how the profession is regulated in other countries, and we made recommendations. And then when we exposed the recommendations, some of my colleagues were like, why do you want somebody else to, the public to be involved with the regulation of our profession? A lot has changed. Remember that the job that we do, we render service to the public. We serve them. And the service we provide is justice. And they need to have a say in that. And in fact, when we analyzed the position in the UK, we found that the reforms in the UK was driven by the public complaining through the competition, the Department of Trade, Fair Trade or something, which is the equivalent of what has just been established in Nigeria, the Federal Competition and Consumer Protection Commission. So the idea that, self-regulation by lawyers regulating themselves or judges regulating themselves, fundamentally has a flaw in the sense that they will regulate in their own self-interest, and therefore, may not give priority to the interest of those they are supposed to serve. So, and that increases cost, etc. And all competition commissions around the world regulate professional associations because, it's a monopoly. Nobody else can represent you in court but a lawyer. So we enjoy a monopoly. And once you enjoy a monopoly, you need to be regulated. There needs to be control.
So are you saying that the era of self-regulation is gone?
Well, I'm not saying that there shouldn't be some form of self-regulation, but it has to be balanced. Yeah, so the reforms which were suggested was to have, first of all, to remove eliminate the fragmentation of the regulation of the profession, focus it properly by having one institution, which we propose to be one council for the regulation of the profession. And under that council, you can have committees and the rest, like body of benchers and other committees will be under that council. There will be term limits. They will no longer have life benchers, for instance. There will be a term limit of 12 years. And also, they will actually be representative of different sectors who would appoint or elect their own members directly. I'm licensed to practice in Ontario in Canada as well. And we just finished our election for our benchers at the end of April. I participated in it, So there's nothing new or strange about it. We actually need to address our issues so that we don't, unwittingly invite the executive all the time to intervene in our affairs, which I think is very bad for the system, really, But we need to put our house in order. Excellent report that we did, but it was thrown under the bucket.
That project started under the tenure of A.B. Mahmood as the president of the Nigerian Bar Association.
Yeah, but actually, to tell you the truth, that project started before A.B. Mahmood. He only just gave it traction. The first set of thoughts started within the NBA, and then it came to the NBA, and this was before A.B. Mahmood sent it to the body of senior advocates, and then they set up a small committee which I headed, and we were looking at it when A.B. Mahmood became the president. He just then blew it up into a big NBA project and put the resources of NBA behind it. It's almost like a movement that has been going on within the profession in an effort to regulate. Now, that regulation of the lawyers is critical, and there are several issues around, serving our public. There's no regulatory objective set in any of all the laws we have today. So in the new draft we did, there's regulatory objective, And it's quite wide, including the mandatory continuous professional development. But we did observe that the constitutional portion of it, which has to do with the NJC, as I've already discussed, would require a constitutional amendment, yeah, to deal with that and also have it more reflective of check and balance, that is needed to eliminate these tensions between the executive and the judiciary, so that sort of like most of the issues will be settled in-house.
I want to take you back to what you said earlier about the relationship between the executive and the judiciary. You described it as cat and mouse, but going forward, post May 29, how do you think that the relationship can be better managed?
People would say that the executive can be accused of not having good intention in some of their intervention, that their intention is to control the judiciary. Maybe there's merit in that, but on the other hand, if the judiciary is clean and there's confidence in the judiciary, the executive will not need to want to control the judiciary, because everybody takes it that whatever the judiciary says must be in the best interest of the country. So that's why I say that the better the quality of the judiciary, the more trust the system has in it, including the executive and everybody. So I think clearly going forward that the two arms have to work to build mutual confidence. The judiciary shouldn't be made by the executive to always be on the edge, feeling that the interventions, that there will always be intervention and attempts to control them. And the judiciary on its own has to give the system confidence that, it's clean and whatever is coming from it is just not based on ulterior motives, but based on the reasoned jurisprudence.
Post May 29, what can the acting CJN, or for whoever becomes CJN, what can the person do better to sanitize the judiciary?
Anything that is done by whoever is the CJN is going to be, not really effective, in the sense that it will be temporary, it will be,
not far-reaching?
It can't be. The reason is that, as I've explained, there's a structural problem.
Who has the responsibility for driving the reforms?
You can see that part of the problem is constitutional, so there needs to be some effort to amend the constitution and change the composition.
Who will drive that?
Well, it could be driven by the executive or by the legislature. I mean, other constitutional amendments have been made. But I would have thought that the profession, because the profession is the one that produces even the judges. So every judge or CJN or whoever, would definitely come from the profession. So the profession should participate in the lobby system, send the bill to the House. What is called agenda setting, should set the agenda,
When you say the profession, are you talking about the leadership of the NBA?
Yes, the legal profession should set the agenda for reform in the judiciary. I don't really think it should be the executive. I would prefer that the profession drives the process of change and not the executive or the legislature. It's apparent that we need to, for instance, reconsider the composition of the NJC. Luckily, we now have the Federal Competition Commission, And I'm sure that at some point, and I had the privilege of being involved with the drafting of that law, so at some point, that commission will probably look at professional associations to see how they are regulated and as monopolies, and how the regulation can be reviewed for all the professions to ensure that they don't work only for the self-interest of the members. The public they are supposed to serve are being protected as well and have representation.